All right. Hi, everybody. This is Felix Shipkevich. I'm the managing member of the Shipkevich Law Firm located in New York City. I appreciate everybody joining the webinar, and a special thanks to Vicky, Maud, Francesca, and everybody at FX Street for helping us putting together these wonderful regulatory webinars. Just wanted to ask everybody, as a matter of housekeeping, to ask questions at the end. I'll be more than happy to answer any questions that you may have, and my contact information will be offered at the end of the presentation. Please feel free to contact me, call me, or email me, and I will be happy to assist you in any further questions on the subject matter that you may have. So let's talk about today's webinar. Today's webinar is going to concentrate on what it takes to start a successful FX introducing broker or commodity trading advisor or company. Particularly, we're going to take a look at what it takes to register a CTA or an IB in the U.S. with the National Futures Association. We'll slightly touch upon some of the other jurisdictions, but the concentration of this webinar particularly will be surrounding registration in the U.S. So let's begin. A little bit about us. We are a boutique firm in New York City, as I mentioned, specializing in FX, commodities, and futures transactions. One of the special projects we do is we regularly register IBs and CTAs with the NFA. We help IBs and CTAs navigate through some of the complexities in the process. And additionally, we also represent IBs and CTAs in the U.S. in helping them comply with the regulatory requirements. So let's talk about choosing a jurisdiction, right? FX is a global marketplace, and those who are listening are not necessarily located in the U.S. and want to find out, where do I register, or should I even register in the U.S.? You really have to think about two items. The first is location of your current and future clients, and your location. So why location of your current and future clients? Well, first and foremost, you have to understand, if you're soliciting clients, if you specifically or directly soliciting clients in jurisdictions where you're required to be licensed, for instance, in the U.S., in the UK, Japan, Singapore, Hong Kong, the list goes on and on, you may be required to register with your local authorities. Therefore, the location of your current and future clients is very important in the process. The other item is where you're located. Your location is essentially important because you need to understand whether the local laws in the jurisdiction where you reside, where you conduct your business, require you to register with the local authorities. And we'll talk about this a little bit further throughout this webinar. But one thing I want you to keep in mind is location of your clients and your location where you do business, where you're soliciting these clients, is trivial in understanding whether you need to register. Okay. So let's talk about the registration requirement process of the National Futures Association. Right? What are the requirements? And first, let's begin with just who has to register. And what you see on your screen are the definitions of who has to register with the NFA as an introducing broker and who has to register as a commodity trading advisor. So there are two types of registrations that are available. Well, there's one type, but it's broken down into two pieces. The first is an independent IB. That's your typical IB that's generally not restricted to do business with an FCM or an ARFA in the U.S. The only other exceptions are if your FCM or ARFA has some type of restriction or exclusivity not to do business with any other brokers, which typically leads to the second category, guaranteed IB. A guaranteed IB can only do business with one FCM or one retail foreign exchange dealer. Guaranteed IB essentially is considered to be an agent of the retail foreign exchange dealer, and the literal interpretation of guaranteed is the FCM or the ARFA who guaranteed. You don't have to maintain the capital requirements, but your exclusive arrangement with that FCM or ARFA means that you cannot really do anything without first going through that FCM or ARFA compliance part. Now, who has to register as an introducing broker, right? I regularly get calls, emails from clients, prospective clients saying, Felix, who do I need to register as an IB? And the key here is, do you solicit or do you accept customer orders, right? Traditionally, on exchange futures and commodities trading, IBs actually do handle customer orders. It's not similar, it's quite different, in fact, with the FX market. IBs generally do not accept orders, but they solicit clients. If you solicit clients who are reside in the U.S., or you are located yourself and you're conducting your activities in the United States, you have to register with the NFA. Okay? So who has to register as a commodity trading advisor? And it's pretty simple. If you're managing someone's funds, if you're advising someone directly or indirectly on how to trade, what type of contracts to trade, you will have to register in the U.S. with with an NFA as a CTA. Again, the same test applies. If you're physically located in the U.S. or your clients are located, the funds you manage in the U.S., you have to be registered as a CTA. Now, mind you, if you're located in any other country, let's say you're located in France, you're located in Germany, England, Japan, but you have a single U.S. client, unless you fall under one of the exemptions that's available, and there are only a finite number of exemptions, you have to register with the local authorities, okay? Similarly, if you're located in the U.S. but you don't deal with any U.S. clients, the very fact that you're located within the U.S. jurisdiction requires you to register if you conduct regulated activities. So let's recap again, right? Who has to register as an IB? Someone who accepts the solicit orders. And who has to register as CTA? Well, that's someone who is managing for profit or compensation or advises other individuals on how to trade foreign currency, futures, and commodity products. Okay? Let's talk about the NFA registration requirements. In this webinar, I'm going to give you a general picture. I'm not going to go into every nitty detail, otherwise the webinar is extremely lengthy. And so my goal is to provide you with what you will have to comply with in the process, right? So what are the registration requirements? Quite similar. You have to fill out Form 7R. 7R is for background information, where you do business, how you do business, policies and procedures. About that a little bit later in the presentation. You have a non-refundable application fee of $200, and then obviously if you become a member, whether it's a CTA or an introducing broker, you have to pay membership due of $750 a year. Okay, so $200 for the application fee, $750 for the membership fee, completion of 7R, and compliance with policies and procedures for IBs. In addition to that, you need a principal. A principal is someone who either is an owner 10% or more of the entity, regardless of whether it's a CTA or an IB, or a managing director, or a person with influence. They have to register as a principal, and you also require to have an associated person. Someone could be both a principal and AP, obviously, and so you'll require to submit forms for principal and AP registration. The fees of that are $85 per AP and per principal. All right, so these are your very, very basic registration requirements. Let's move on and talk about what else is needed, right? If you're an independent IB, you will have to provide financial filings. Financial filings are statements that are certified by an independent CPA, and obviously they have to be very recent. As you see on the slide, they have to be within no more than 45 days prior to the date of filing with the NFA. Okay. This area is always quite interesting from experience. Let me tell you a story. I recently had someone who was applying to be an IB. We went through the process, and when they needed to go and obtain independent financial statements from the CPA, well, they went to just a regular accountant, regular CPA who had no experience in the futures commodity market. The type of certification that was provided by the CPA was not sufficient to the NFA, and so the client had to go back and have to, obtain a different CPA with more knowledge about the market. One thing I want you to take away from this is if you're registering as an IB, you will have to provide financial statements, and I urge you to make sure to carefully select your CPA for certification of financial documents. You shouldn't run to any CTA, and it's going to be money well spent. Okay. A guaranteed IB is going to have to file Form 1 FRIB guarantee agreement, which is a form that gets filed with the National Futures Association, letting them know that you're being guaranteed by a specific FCM or an RFA. Okay. What else is required? Well, the regulators want to make sure that you have taken the necessary exams. Up until last year, you're required to take Series 3. Series 3 was a commodities futures exam that was administered by FINRA, formerly NASD. And since the introduction of the FX rules in the U.S., you now have to take the Series 34 exam, which is a specific FX exam that you have to pass if you conduct FX activities as an IB or a CTA. Both exams, I personally don't think are quite challenging. With maybe a few weeks of studying, you should be able to pass. Okay. Now, for CTAs, as we touched upon a few minutes ago, the registration is a lot simpler than for IBs. So it's quicker, it's less expensive, and less is required. Here's basically what you need to do if you're managing somebody's funds and you're registering with the NFA. Okay, so 7R, right? Form 7R, as I mentioned to you a few minutes ago, is a form that collects your background information, collects your disciplinary history, collects information about you and the entity that you're going to be conducting your CTA activities with. The fee is $200. You pay a membership fee of $750 a year. You need to complete a principal registration of AP form, which is Form 8R, and $85 per principal and paid AP. So this is pretty simple. Okay, what's the process, right? What is the registration process like for IBs and CTAs? As I mentioned to you, the CTA registration process is quite simple. You have an NFA application, which is Form 7R and 8R, and you need to provide a disclosure document unless you're exempt. The disclosure document needs to include your trading strategies, your risk assessment of the strategies. It's a pretty comprehensive document that I think is actually quite important to you, not only from a regulatory point of view, but from a liability point of view. If you potentially get sued by a client who may allege that you have incorrectly handled the trade, so if they weren't suitable for trading, the disclosure document is something that protects you. IB process is a little bit more burdensome, though I don't want to scare anybody. It's not that difficult. You need the same type of application, 7R and 8R. You also need policies and procedures, and I'll discuss what policies and procedures you need to put together. You need audited financial statements, which we just covered. That should be certified by an independent CPA. You need to have regulatory capital. Independent IBs need to maintain $45,000 in regulatory capital. And guaranteed IBs don't have to maintain any capital because they're guaranteed by their respective FCM or an RFA. And finally, the process includes the review by the National Futures Association. We assign an analyst, one auditor, who's going to accept your IB application, is going to review your application, and subsequently, if they have follow-up questions regarding your application or policies or procedures, they'll email them to you or your advisors or your counsel, and you'll have to deal with that. And as I said, the process is a little bit longer. So, how long is the registration process? Right, the CTA registration process could be quite quick. I mean, I've seen CTAs get registered within a few weeks. If there's no backlog with the NFA, your application could get approved, as long as you submit your application and fingerprints, exposure document, within, I've seen it 2 weeks, 3 weeks. I've also seen CTAs, taking their time, submitting fingerprints, for instance, so the process could, drag on. So it's a relatively short process. It's in your hands and you have control over it, but if you get all your stuff together and your paperwork together, you get, registered as CTA fairly quickly. An IB process, lately has taken quite longer than before. 5 years ago, an IB registration take, rules that came into place at the end of last year, there's been a backlog of IB applicants with the National Futures Association. So the process, I would say on the lower end, will probably take 2 to 3 months. On the higher end, 5 to 6 months. A lot of it's going to depend on you. You know, if you submit your application, your fingerprints, your policies and procedures have your I's dotted and T's crossed. You have your regulatory capital to show. The process could be, you know, as I said, 2 to 3 months. However, you know, quite often the NFA would review policies and procedures and have a lot of follow-up questions about how these policies and procedures will be implemented, or, you know, what else you should include in your policies and procedures, and therefore the process could, you know, drag on for 4 or 5 and sometimes 6 months. Right? Dealing with someone who actually had his IB application for 9 months. You know, it's not fault of the NFA. It's actually because the person, you know, hasn't finalized the policies and procedures. So, CTA process is quite simple. The IB application process might take a little while. All right. Policies and procedures. We just touched upon them, right? These are required for introducing brokers. You're required to have an AML policy. The NFA pays very, very close attention on how you will be compliant with U.S. AML requirements. You're required to have a business continuity disaster recovery policy and procedures. The NFA is concerned that if tomorrow there's some terrible event that affects your business and you can't operate, what backup plans do you have? They want to make sure that a copy of the business continuity disaster recovery plan not only is acceptable to them, but actually also holds, you know, stored on site. So, you know, I've had, you know, questions from the NFA for some of my clients. Well, we like your business continuity and disaster plan. That's wonderful. Where do you keep a copy? And then, you know, you have to tell them where you keep a copy and who keeps a copy and how often do you do, you know, your business continuity testing. You need a promotional material policy. Obviously, the NFA wants to make sure that the type of promotional information that you put out there is, you know, is reviewed by, you know, your compliance person and is, you know, approved by a principal. You also need to make sure that you have a policy that addresses supervision of APs. APs are your work, is your sales staff, right? You want to make sure that you have a customer complaint procedure. You know, if a customer complains against introducing broker, how do you handle this procedure? Who reviews the complaint? How do you respond? How long does it take you to respond? So you need to have a policy on that as well. You need to have a source of assets letter. You want to make sure they understand, you know, that the assets that are used by this IB, you know, are clear of any, you know, liens or debt. For securities broker dealers, a copy of the most recent report from a DSRL. So if you have a FINRA registered broker dealer, they want to make sure that you have a clean regulatory history. If you have a subordinate loan agreement, right? If you are taking a subordinate loan from a lender, you need to provide a copy, and that actually, because if you submit a copy of the subordinate agreement, it has to be approved. If you're conducting FX business as an IB, you need to provide copies of signed documents and to the counterparty. So if you are an IB and you are introducing accounts to take 3 different FCMs or RFEDs, you're going to have to provide that to the NFA. You need to make sure that you're authorized to conduct those activities on behalf of those firms and solicit clients for these firms. And obviously the NFA conducts a review of the firm's financial statement operations. Typically IBs and CTAs will get a visit, an in-person visit or an audit every 3 years. So not only are your policies and procedures important at the time of the registration process, but you want to make sure they're up to date, and you want to make sure that these policies and procedures are time-stamped, that you regularly update them. You know, if there's a new, AML, notice or requirement coming out of FinCEN that you have to adopt, you make sure that you track those changes so that you'll be able to show to the NFA during their audit that, look, I stay on top of the AML requirements, and here's what I do. You can also outsource your AML and KYC, which is also a customer process, to an RFED and an FCM. That's obviously going to depend on your relationship with that RFED or FCM. In that case, the NFA will want the FCM RFED to provide a FCM compliance department that they are conducting, they're taking on the activities, AML and KYC activities on behalf of the introducing broker, just so the NFA, has some, verification that someone is conducting KYC and AML. Okay. CTA is required to maintain a disclosure statement unless you fall into one of the exemptions. And the exemptions I mentioned top is CFTC Regulation 4.21A, if you deal with qualified exempt parties. I don't want to talk about this during this presentation, but obviously if you feel that you might be exempt or you can find out about them, give me a call or email me and I'll tell you whether you do fall one of the exemptions. But let's talk about what the CTA disclosure statement should have. Okay. You have to share a cautionary statement, a risk disclosure statement, a table of contents, name and address of your business, state when the CTA intends to use the disclosure statement, FCM and RFED where the account will be maintained, who is the introducing broker, background of the business, principal risk factors, trading program, fees, conflict, litigation. I mean, this is a very comprehensive document. And when I tell you that you have to have every one of these bullet points listed in the CTA disclosure document, you have to have it. If you don't have it, I've seen CTAs being sanctioned by the NFA for not having the proper risk disclosure information for their clients. Okay, so I have CTAs who I've met CTAs, I have clients with CTAs who actually took the time to prepare a comprehensive document that's not only required by the NFA rules, but also protects them, right? I mean, this is going to be the piece of paper that's going to, protect you in the event of litigation, assuming you haven't done any wrongs. I also have seen CTAs that basically went online, copied and pasted a few things together, and then down the road were sanctioned by the NFA for not having the proper disclosure. Okay, so quite an important topic. Let's talk about the fees, right? The fees are pretty simple. Look, it's $200 for the application fee. It's non-refundable. So if you're looking to submit an application, you have to pay that fee. If you change your mind a day later after that fee has been accepted by the NFA, you can't get it back. It's non-refundable. Okay, it applies to commodity pool operators as well, applies to CMs, but just so you know, it's non-refundable. Okay, and then for every principal in IP, you have to pay $85. So say if you have a firm, you have an IB that has 4 principals and 2 APs. Well, you're going to pay, 4 times, 85 and 2 times 85. And then if some principals are also APs, then that's on, right? There's no way to get around it. It's non-refundable. In my opinion, these fees are fairly reasonable, especially in comparison to some of the other jurisdictions that require application. And then you pay your annual dues as an IB, CTA, CPO, commodity pool operator, $750 a year, non-refundable. You pay it every year. Look, some people pay more for their car insurance a year, so fairly reasonable cost. And so what are the other costs, right? CTA application typically, you can do yourself. You don't need a lawyer. You don't need an advisor. I think you need someone to help you with the disclosure document. And if you're a serious commodity trading advisor with a book of business or you're starting out, I just suggest to you consult with someone who has experience in creating, drafting, editing disclosure documents. IB process, as I mentioned, takes a little bit more time. You will have to have a lot more interaction with the NFA during the process. Can it be done on your own? The answer is yes. Have I seen applications that are stale and people scramble for policies and procedures, and by the time they decide to hire professional help, the NFA is not happy, the application's been with them for 6 months. Look, it's not a big expense to hire an outside advisor. You hire a consultant, you can hire a lawyer, but make sure you hire someone who's done it in the past. It's a worthy investment. You want to get this done, and you want to get this done right, and you want to get this done in the right. Okay. Obviously, consultant advisor fees will vary. I suggest that in your due diligence process, you find out how long somebody has been in business, how many applications they've done. You also want to make sure this person has a clean record. The last thing you want to do is hire someone who has been previously sanctioned by the NFA or the CFTC. Sometimes cheaper doesn't mean better. Sometimes you can find somebody inexpensive, but I think for a not introducing broker registration, my advice is for you to look for outside help unless you're familiar with the process, right? So that's it. That's a pretty big overview, general overview of what the process, the cost, the length of the process is. My contact information is above. My associate contact is there as well. I'll take any questions, and let me know if we can be of any help. Thank you. All right, I got a couple of questions. So let me do them one at a time. The first is from Pip Stamen. If I'm living outside the U.S., in Europe, let's say, can I open an IB and operate in the U.S.? The answer is yes, absolutely. If you have U.S. clients, or you intend to solicit U.S. clients, or if you want that IB registration because of ability issues, you want to tell your clients, prospective clients, that you are regulated by the CFTC and the MFA, I think it's too the expense. So the answer is yes. And in fact, I think with the recent adoption of the FX rules and requirements for IBs and CTAs and CPLs registered, we've seen a rise of applicants coming outside of the U.S. wanting to register. I mean, the capital requirement is $45,000 US, unless you're guaranteed. You don't have to maintain any capital if you're guaranteed by an FCM market. So the answer is yes. Okay. Next question is, how's the normal process for a retail FX trader? I guess what I'd like to clarify is the process is no different for a trader than anybody else. The fact that you have trading experience may actually help you throughout the process because, you understand the marketplace, but I don't think it's going to necessarily expedite the process. I don't think it's necessarily also going to, make things a lot easier, especially in the IB application process. What you need to be careful of if you're a retail trader, if you've managed some of your accounts and you live outside the U.S. and you have a history, the NFA is going to want to see your trading history. They're going to want to see how experienced you are, and they may ask questions. Okay, so that answers your question. Let me know if anybody else has any questions. Well,